One of my greatest qualms with game companies is when they patent game mechanics. And I've talked about this before, where it feels like they're patenting fundamental building blocks of unique artistic expression in this particular medium. And Nintendo has recently been going all out when it comes to patents due to the fact that they're involved in a lawsuit with Pocket Pair, the developers of Palworld. Nintendo believes that a lot of the designs in Palworld are very similar to those of Pokemon, but instead of making that argument in court, they're saying that Palworld basically infringed on multiple patent rights, with Nintendo trying to make the argument that Palworld steals from Nintendo's gameplay inventions. It just doesn't feel like a genuine, legitimate argument. It feels like they are taking advantage of and abusing patents in order to get their way. Now, there's two sides to this whole situation. There's the Japan side of things with Nintendo's patents in Japan, and then there's the patents in America, Nintendo's patents in the US. In my previous video on this topic, I discussed a setback that Nintendo faced recently when Japan's patent office rejected one of Nintendo's patent applications that is relevant to the Palworld lawsuit involving Pokemon catching and summoning. This was reported by GameSir right here on October 29th, 2025. It discussed pending application number 2024-031879 that is a sibling of one of those anti-Palworld monster capture patents and the parent of another. It has been rejected because the patent office, after third-party submission of prior art, determined that the claimed technique lacked an inventive step. GameSpray has this really useful legal dictionary that helps define what those legal terms are. So inventive step is it is not enough for a patent application to be novel or to present something not already known in the prior art, but in order for the application to succeed, it must contribute something innovative, an inventive step that is not, for example, an obvious idea to combine two or more pre-existing concepts in a way that a person having ordinary skill in the art would have done anyway. So there's the fact that the idea of capturing monsters and then summoning them to do battle for you or to kind of aid you in some way, that's an obvious idea in the same way that people have tamed animals and have used them for their own needs and purposes. But then on top of that, there's the submission of prior art, which basically cites that other games in the past prior to Nintendo's patent application have done similar things, and therefore Nintendo's not actually inventing anything new. And while this particular rejection from Japan's patent office isn't final, we are seeing the patent examiners scrutinize this patent pretty thoroughly to the point where they are looking at other games that might have done similar things. And if this rejection does become final, it might substantially help tip the scales in favor of Palworld and Pocket Pair due to the fact that this one patent that was rejected is linked to all these other patents that might also be called into question and to scrutiny if this current patent's rejection is finalized. So that's what transpired on Japan's side of things, but today I'm here to talk about new developments surrounding the US side of things, where Nintendo has faced scrutiny for one of their patents that was granted, but the US Patent and Trademark Office is revisiting this patent and re-examining it to see if it's valid. So this article from GameSray is what I'll be talking about after I kind of give you the full context of what led up to this. But suffice to say that I do think this development is a good thing because the patenting of game mechanics limits game development as a whole. It limits creativity in the game development landscape. All right, so let's talk about the US side of things. Back in September 9th, 2025, news outlet GameSray reported that a week prior, on September 2nd, 2025, the US Patent and Trademark Office granted Nintendo another patent, US patent number 12,403,397, which covers the fundamental gameplay mechanic of summoning a character and letting it fight another. The related patent application was filed in March of 2023 and has now been granted by the US Patent and Trademark Office without any objection. Now, it's worth noting that this is a very specific version of summoning a character and having it battle for you, specifically concerning Nintendo and Pokemon's auto battle system that they utilized for recent Pokemon games. So for something to be considered infringing this patent, it has to meet all the following criteria listed here, where there must be a PC, console, or other computing device, and the game is stored on a drive or similar storage medium. You can move a character in a virtual space. You must be able to summon a character. They call it a sub-character, by which they mean it's not the player character, but for example, a little monster such as a Pokemon that the player character has at its disposal and can control in a more limited fashion. Then the logic branches out with items 4 and 5 being mutually exclusive scenarios before reuniting again in item 6. for being this is about summoning the sub-character in a place where there already is another character that it will then, when instructed to do so, fight. Number 5, this alternative scenario is about summoning the sub-character at a position where there is no other character to fight immediately. And then finally, number 6, this final step is about sending the sub-character in a direction and then letting an automatic battle ensue with another character. So yeah, it very clearly describes Nintendo's auto battle system. They're not patenting summoning characters and making them battle in video games across the board, but that doesn't change the fact that this patent isn't disconcerting. Even this Verge article that aimed to clarify that Nintendo isn't patenting summoning characters and having them battle for you across the board admitted that that doesn't mean the patent isn't concerning for other game developers. Whether this particular patent could unreasonably restrict the mechanics of other games is in part determined by any given court's interpretation of the patent and the law. And with this whole lawsuit against Palworld and Pocket Pair, we are seeing Nintendo abuse patents to try to make these weak links and connections to this idea that Palworld is infringing on Nintendo's patents when Palworld actually plays very differently from your Pokemon games. What Nintendo's really mad at is that some of the Pals look very similar to Pokemon design, but because that's a tougher legal argument to make, they're pursuing this patents infringement route that isn't really the issue at hand, because from a gameplay perspective, you cannot confuse Palworld with Pokemon. There are aspects that they draw from Pokemon, but ultimately, it is a very different kind of game. And just the very idea of any video game company owning any patent for any game mechanic, no matter how specific it is still not good for the games industry, because there might be developers out there who might want to take this thing that Nintendo patented and do something of their own with it, add a unique twist to this gameplay formula. And now they're not allowed to do that because of the looming threat that Nintendo might send a lawsuit their way, because Nintendo wants to have a monopoly over specific game mechanics. Which is why Nintendo being approved to receive this patent by the US Patent and Trademark Office made such waves across the internet, why there were so many headlines surrounding this, and why so many people were concerned in the gaming community. Now, the thing about that backlash is that it kind of worked, because the US Patent and Trademark Office, seemingly because of the vocal backlash, has decided to revisit that patent that they granted with no objections. Right here we have an article published by news outlet GameSpray, published just today as of the recording of this video on November 4th, 2025, whose headline reads, "Huge blow to Nintendo, head of US Patent Office takes rare step to order a re-examination of summon subcharacter and let it fight in one of two modes patent." This is the exact same patent that was approved back in September, US patent number 12,403,397. The director of the US Patent and Trademark Office determined that, looking at previous patent applications filed, there might be precedent for Nintendo not being the inventor of what they're trying to patent, not being unique in that regard, not having that inventive step. As GameSpray puts it here, the reason the director re-examined this patent was because of two older published US patent applications, one of which was filed by Konami in 2002 and the other by Nintendo itself in 2019. It was published in 2020. Either one of those prior art references teaches a player being allowed to perform a battle in a manual mode and in a simpler automatic mode, which apparently bears enough resemblance to the current Nintendo patent that's being scrutinized that it might potentially invalidate Nintendo's patent. Now, this is by no means a rejection of this patent. They may very well decide that it still holds up, but the fact that there is a re-examination at all and the fact that more scrutiny is being applied to this patent is a good thing, because now we can not only bring up the fact that there are past patents that may have patented something similar or may have attempted to patent something similar, making this patent from Nintendo that came later not entirely unique. We can also start to make the argument that prior art that have utilized similar mechanics can be presented that shows that Nintendo cannot patent this monster summoning and having it battle mechanic because it existed before this patent application took place. Or as The Verge puts it here, two main ways one could potentially invalidate this specific patent: by anticipation or obviousness, and by subject matter eligibility. The first argument, anticipation or obviousness, highlights that if what Nintendo's trying to patent has already existed before in other prior creations, then it doesn't really count as a new invention, therefore Nintendo can't patent it, with The Verge highlighting an example where StarCraft has this command that you can do called attack move, where you can take the characters you've summoned and then have them go to a specific spot, but along the way, if they happen to meet what would be considered to be hostile entities, they will automatically attack them, which might be similar enough to what Nintendo is patenting with their auto battle system in Pokemon that it might not constitute as a new invention because something like StarCraft has already done it before. StarCraft did it many years prior to Nintendo's original patent application. And then the second argument, subject matter eligibility, quote, focuses on whether the patent's claims are directed to an abstract idea and contain no inventive step beyond that idea. So with Pokemon, the idea of capturing monsters, taming them, and have them follow your commands is similar to the abstract idea of when humans would tame creatures and animals in order to be able to issue commands or be able to utilize them in ways that are helpful to them. Whether it's having dogs serve as shepherds, or whether it's riding horses, you name it, or having dogs, sniff out drugs or attack hostile entities or serve as guards. It's an abstract idea that is similar to what Pokemon is trying to patent here. And then an example that The Verge provides is that this automatic and directed combat sounds a lot like ordinary military hierarchies. There would be a pretty good argument that the patent claims, therefore, are directed to an abstract idea. And if the court agrees that the abstract idea of, ordinary military hierarchies where they can issue similar orders is somewhat in line with Nintendo's patent and what they deem to be a unique idea, then that idea may not be that unique and it may be too abstract to be able to be patented. So with this US patent case essentially being reopened, with this re-examination happening, those kinds of arguments could potentially be made, which may enforce further scrutiny on the patent itself, which might hopefully and potentially lead to a rejection that will invalidate a lot of other patents. GamesFrey, and what legal knowledge they have, believe that it is highly likely that the U.S. Patent and Trademark Office will revoke Nintendo's 397 patent, referring to the last three digits of this specific patent right here, 12,403,397. And if this re-examination leads to the invalidity of this patent down the road, then this could completely undermine Nintendo's lawsuit against Palworld, which so heavily relies on some of these patents that they're now trying to update and keep track of, whether it's the ones from Japan, some of which are getting rejected, or the ones in the US, some of which are being further scrutinized. GamesFrey further highlights how fragile this patent application is because the re-examination apparently relates to specific claims like claims number 1, 13, 25, and 26, and if they fall, which GamesFrey believes will most likely happen for whatever reason, the remaining ones, which depend on those claims, will fall as well. This is a house of cards, is how GamesFrey puts it. I'm no legal counsel, and I don't know enough about the legal system on this front when it comes to patents to be able to lend validity to this. I'm just relaying the information that is currently here. And apparently the U.S. Patent and Trademark Office deciding to revisit a patent, that's something that happens very rarely. GamesFrey highlights that the last confirmed director-initiated order of an ex parte re-examination was in 2012. Like, there are instances when patents are re-examined because another entity will claim that that patent is invalid for whatever reason, but in terms of a director-initiated order of a patent re-examination, that is extremely rare and hasn't been seen since 2012. For this particular instance, as GamesFrey puts it here, there was no other company involved. The U.S. Patent and Trademark Office director himself took the initiative. What suddenly instigated the U.S. Patent and Trademark Office's director to re-examine this specific patent? It's hard to say for sure right now, but GamesFrey believes that it has in large part to do with all the negative publicity due to the fact that this issue has been covered so much, and the U.S. Patent and Trademark Office has in turn faced a lot of scrutiny. And yeah, I remember when that patent was first granted. I covered this myself in a video when all of that happened. And yeah, the talk on social media was pretty significant. We're talking about millions of views and tens of thousands to hundreds of thousands of likes on posts that were addressing this and criticizing Nintendo and the U.S. Patent and Trademark Office for allowing this to happen, and how detrimental this is to just games development as a whole, and how hypocritical it is when all games ultimately draw from other games. They all draw from each other when it comes to those gameplay mechanics. When you look at Nintendo's own games, you can see where they pulled a lot of their inspiration when it comes to gameplay mechanics. Nintendo didn't pioneer all of the gameplay mechanics that they're using, but they're still drawing from those, utilizing them to their own benefit while, adding their own twist and their own unique artistic expression to it. So for Nintendo to do that and then try to engage in legal action against the ability to do that is hypocrisy at the highest order. Nintendo's games wouldn't be what they are if it wasn't for what game mechanics they took from other games, and those games wouldn't be what they are if it wasn't for the game mechanics that they took from other games, including Nintendo's. It's this sharing of basic ideas from which new unique things can be built upon. And any sort of restriction on that front and the way that limits game development, like all of that is seen as aberrant. Which is why when most recently Nintendo's pen in Japan got rejected, the amount of interactions, the millions of views and likes and people just celebrating the W that they deemed this to be. I mean, right here, again, millions of views and tens of thousands of likes. That all highlights how much the gaming community rallies for the sharing of game mechanics ideas. Like, it's one thing if a game looks one-to-one a copy of another where you could confuse one for the other because the unique artistic expression has been copied in the same way that Light of Motram looks so goddamn similar to the Horizon series that a lot of people would argue that that specific lawsuit is warranted. And if Nintendo made the legal case that Palworld copies designs from Nintendo, then, maybe there'll be less scrutiny. But the fact that they're abusing patents that they shouldn't own in the first place, but that they own anyway, and then using those patents in a way that isn't relevant to what Palworld is being scrutinized for, like, that was not why the patent system was created. It was not created for that kind of abuse. It was created for protection. And Nintendo is not using it for defense. They're using it for unreasonable offense. And the funny part is when you look at recent leaks of upcoming Nintendo titles, specifically where Pokemon is concerned, people have noticed that one of the upcoming Pokemon games bears a strong resemblance, or at least has some elements that take inspiration from Palworld-like mechanics. Not to say that Palworld established the mechanics that are highlighted here that will seemingly similarly be featured in this leaked Pokemon game that is upcoming or in development. But yeah, Nintendo is taking things that other games have done before to put their own unique twist on that formula through their own IPs. So yeah, given that Nintendo does it too, to say that other companies doing something similar when it comes to game mechanics is wrong, again, it's just pure hypocrisy. It's a sentiment that a lot of people share, which is why if you go to social media right now, despite the fact that this re-examination of this US patent was only reported on a couple hours ago, you can already see hundreds of thousands of views and tens of thousands of likes and tons of people supporting the re-examination and Nintendo not getting away with this particular instance. Because the normalization of a corporation or any entity being able to own the building blocks of a specific art form and medium, that's the death of art right there. Freedom of expression is what makes art possible, and the tools with which to express, like game mechanics and brushstrokes and literary devices and, chord progressions for music and, cinematography techniques for film and so on and so forth, those must remain free and available. It's what you do with those tools, what you do with those building blocks, and what unique thing you create from those, that's what makes your art unique from everyone else's. At the end of the day, only time will tell how all of this will play out. But the fact that the re-examination is happening at all, the fact that any sort of scrutiny is happening at all, I see as a positive development. But that's my personal take. I'd love to hear what your thoughts and opinions are on all of this in the comments below. And to be further updated on all things gaming news, reviews, and discussions, stay tuned right here on Young Yeah. I'll see you guys next time. Young out.